Hello everyone, we welcome you to our first lecture on real estate, and this is for Ontario bar exam. You have a subject real estate, and this is the first lecture. So you are allowed to share the link of this lecture with any LSO candidate. So I'm going to show you that which resources you have got access to. So you type in the Google NCA online teacher. Our website will show up. So this is the home page of the website. So can you see that? So you click on that and then you will be able, there are different options to purchase the Ontario Bar services. So if you click over, you can see solicitors live classes with video recordings, and this is one of the lectures. Then solicitors recording with notes is the second option, and solicitors recordings only is the third option, and solicitor single course enrollment is the fourth option. Many candidates find business organization very hard, especially the tax part of that. So that is why we are also providing services for single course enrollment. So once you have purchased any of the services, then you click on the right side, top right side, and then you will see sign in. Here it will show you your name, whatever username you have used, and then there is a yellow button, access courses. We click on access courses, and then you will be able to see the number of courses which you have purchased from our website. So we will go to solicitors live classes. So on my side, it shows on page number 2, but on your side, it will show on page number 1. So solicitors live classes, or maybe I think it is arranged alphabetically. So I may have to go to page 3 to access that. So solicitors crash course. Yes, solicitors live classes. This is how it will show up on your site. Solicitors live classes, Ontario. And then you are able to see recordings, and then you are also able to see instructors notes. Recordings mean that most of you are attending our live classes. Then you can see for the June exam, so far we have conducted 8 to 10 hours of classes on professional responsibility. We have also conducted our classes for business organization. If some of you are still planning to join, and you will get access to the business organization, which is a compulsory or mandatory subject in the solicitor exam. So every lecture is around 2 hours, 15 minutes to 2 hours, 45 minutes. Some minutes of the lecture may not be recorded, but you can see lesson 1, 2, 3, scroll down, and then there are 11 lectures. 11 lectures mean that your instructor, Miss Hannah, she has conducted more than 24 hours of lecture just on business organization. This is for the June exam. So if any one of you is planning to join now, so you will get access to 24 hours of business organizations recording. Then you also have got access to real estate February session. So, and today is the first session on lesson 1, real estate. So that will be named as real estate lesson 1 June exam. So we provide multiple resources because some of you are writing both exams, barrister exam and solicitor exam. If that is the case, so we advise you to please move faster than the class and listen to the recordings which you already have got access to. You can see on the bottom left, bottom right, you can see page 1 of 11. So there are 11 pages where you have got access to the recordings. So I'm going to page 2, and then um, um, you can see February recordings as well. So real estate lesson 5, real estate lesson 6, real estate lesson 7. So I am imagining that this time you will have more lectures than the February exam, because in February exam the time is short. So maybe and also some candidates like brief version. So Miss Hannah is providing you two options. One, if you like short versions, so then you will be listening to February recordings, which are also kind of latest. If you like detailed recordings, then you are already attending June classes, and then you will also get access to the June recording. So this is all about the recordings. If any member has any question, especially who have joined late, Iti, if you have any question, please feel free to ask. So these are the recordings parts. Now, if you click on instructor's notes, so these notes have been prepared by your instructor, Ms. Hannah Mall. So it also has mock test. Many candidates ask me, sir, is that part of the package? Yes, it is part of the package. So you get mock test for business organization, which is one of the compulsory subjects. So mock test one, question and answer on business law. Mock test exam two, only answer. Mock test exam two, these are only questions. Then additionally, there are some more practice questions, which Miss Hannah, I believe, is doing practice in every session. Some members would ask me, sir, is there a mock session? Our every session is a mock session. Our every session is a mock exam session. Then if you want additional questions, so there is another service provider. They have, as a courtesy, they have given free sample practice questions. If you need more, you can directly go to their website. Now, these are the four courses which are part of your Ontario Solicitor exam. One is called Business Law, second is Wills and Estate, third is called Real Estate, the fourth is called Professional Responsibility. You have access to them. Just click on View Full Screen and then you will be able to see them. And then this is all about that. If you have any question, I am free right now for 30 minutes and then I have to start my own classes. But if you have any questions, you are welcome to contact me. Thank you. That is all about from me. I think Hannah, now you can start the lectures whenever you are ready.
Yes, Amar, a very important aspect of this tutoring is that we are going to have separate mock tests for every subject area. Like, for
Mhm,
instance, our first mock test for business law is
mhm.
on April 26th. And then we will have mock test for real estate. We will have mock test for wills and estates. And towards the end, I will also take a full length test as well. So, what we are going to, or what we endeavor is to put you in those same examination conditions where, let's say, you just have a minute and 15 seconds per question. You have to write the answer and move on. So, that is something we did last year as well. And I intend to continue with that even this year. So the first mock test, because almost 90% of you, 95% of you are our regular candidates, I had already announced the mock test for business law. That is on April 26th, which is next Sunday at 3 p.m. With that said, I will now start the session.
And
What's difference between the two estate subjects? What estate? One is real estate and one is wills and estates. Okay.
Hannah, so you have stopped sharing the screen.
Yeah.
Mhm.
You want me to share the screen?
No, 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 I'm saying if you can go back to the original setting, like stop sharing the
Yeah,
screen,
yeah, yeah, yeah. That
so
that
that
is
only
the,
you can, yeah. Mhm.
certainly. Thank you. Um, Good morning, everyone. I welcome you all to our first session on real estate law. My name is Hannah. I'm a barrister and solicitor in the province of Ontario, and nothing I discuss today constitutes legal advice. It does not give rise to any solicitor client or barrister client relation between us, and that includes fiduciary, contractual, professional, and agency relation. Whatever I will discuss over the course of next few hours is only meant for educational purposes. In addition, you're strictly prohibited from recording attending this session. And in the event you do so, not only will you be breaching my privacy, but you shall be breaching the privacy of every single candidate attending today's session. Please note the materials that I have prepared exclusively belong to me. They can neither be printed nor be downloaded and must not be accessed in any unauthorized fashion. Furthermore, I request you all not to ask any questions stemming from the examination content as defined by the Law Society of Ontario in your respective lawyer licensing agreements, lest it jeopardizes the process for the other candidates. With that said, I will start sharing my screen and we are going to start with the very first topic, which is about understanding agreement of purchase and sale. Actually, let me take you, let's go a step back and understand what exactly do you need to understand for real estate law or in order to successfully pass your solicitor's exam. You see, real estate law requires us all to have substantive knowledge of certain statutes, which list is given over here. This list has been procured from the website of the Law Society of Ontario. In addition, it requires us to have um, a superficial or let's say basic knowledge of certain other statutes, which means we're going to touch upon these statutes, but we're really not going to dive deep in them. So, the ones that we are really going to sit and analyze and understand are here, which basically says substantive knowledge of this list and secondary real estate statutes, which means we will know the purpose of this particular act, and we will also talk about this act in the passing, but we are not really going to spend too much time analyzing what these statutes are all about. Let's now understand what is the life cycle of a typical real estate file. You see, a typical real estate file has goes through this life cycle, which means it does not matter whether you are purchasing a condominium or you're purchasing a cottage or you're purchasing a detached house. These stages are common to all, right? So the first step is contractual aspect. You see, real estate law is essentially, or the basis of real estate law is contracts. Because at the end of the day, you are entering into a contract, right? So you enter into an agreement of purchase and sale, which then becomes firm. And then you enter into a sale agreement, which is when, the property is registered in your name. So essentially, what we are looking at is an area where principles of contract are pivotal, right? You cannot say, oh, well, we're studying real estate law. Sure. But what is the basis of that law? The basis of that law is contract law. And on top, you have statute of frauds, you have other legislations. So they're built on the very foundation of contract law. So when we speak about real estate, we start with a contract, understanding a contract, which is agreement of purchase and sale. So let's go back and understand the, the life cycle. The first is the contractual aspect. The second is due diligence. It is here that we, I call this operating on a property. Have you seen how doctors operate? What do? They open up the body and then they try and detect where the problem is. So due diligence is that surgical process, which essentially means at this stage, you are going to look at every aspect of that property. You're going to look at the title. You're going to look at if there are any liens on this property, if you have any claims that have been registered against this property. You're going to check whether this property has all the requisite licenses. Does it have all the requisite registrations? So, due diligence is that surgical process that you undertake in order to understand whether your property is at any point in time being attacked due to issues of non-compliance because of an existing mortgage. What is the quality of title you are going to get? All that is understood through this process of due diligence. After we are through with our conducting this surgery, our next stage is requisition. Requisition means you are now going to ask questions from the other side. For instance, well, it shows your property has three different mortgages on it. So you have one mortgage from a financial institution and two from private money lenders. So can you give us more details? It appears you've not paid your property tax because that is what our due diligence has revealed. Can you let us know by when will you pay this, or are we required to pay it? So these questions that you ask from the seller form the crux of requisition. The word requisition basically means asking questions. So at this stage, I am asking all possible questions. I want to know, whether there was any vendor take back mortgage on this property. I want to know when was the last time you paid utilities. If it is a condominium, have you paid the maintenance fee that you're supposed to pay? If, let's say, it's a commercial property, then I want to know, you have you at any point in time broken the bylaw? Is there any bylaw infraction? So I want to know everything about the property. It's almost like I want to know what I'm purchasing. So what do you do when you actually go and shop? You pick up a dress, you check the fabric, you check the stitching, you check the quality of material, you check the price, you check if it's on sale, if what is the money back guarantee? Can I get my money back, or is it just an exchange? So it's the exact same process, just that the stakes are way higher. So obviously, due diligence takes a lot more time. And then, whatever your questions are, whatever you have discovered, then is questioned. You sort of question the seller's lawyer and go like, okay, we have done our due diligence. These are our questions. Now you're supposed to respond to them. After this stage comes the stage of addressing requisitions. So you asked me questions. Now I'm going to respond. And my responses would look like, the property tax has already been paid. It was paid yesterday. We will send you the receipts. Perhaps whatever you're looking at has not been updated. The utilities have already been paid. Here are the receipts. We have at no point in time transgressed any of the bylaws. Here is the proof. Um, yes, there was a vendor take back mortgage which we intend to satisfy over the next couple of days. And once we are through with that, we will send you the receipt. So essentially, at this point in time, the seller's lawyer is trying to answer questions so that the, the transaction can move further. After all this, it's not really after, because simultaneously you have to arrange for financing, right? And what is financing? Financing is, well, the property costs $1 million. You have just 200,000. Where are you going to get the 800,000 from? So financing is the stage when you try to um, arrange for the balance funds in order to close the transaction. And while doing that, you would go to a financial institution. You might go back to the vendor and go for vendor take back mortgage. You might go to a private money lender. You might go to your own parents and get financing from them. The idea is to arrange the funds that you require in order to reach the final stage, which is closing. So these steps are common. It does not matter what you are purchasing, which kind of real estate you're purchasing. These steps remain the same. What does change, and you might go like, so if they remain the same, why are we studying commercial and residential separately? Why are we studying cottage and condominium separately? The reason you are is going to understand different types of properties, or you need to understand how different types of real estate actually works, is because the due diligence varies. The due diligence that you need for a condominium is different for what you require for, let's say, a cottage. What you need for a residential tenancy is very different from what you require for commercial tenancy. So the steps that you undertake under these stages, they vary depending upon the kind of real estate that you're looking at. So real property transaction, essentially, basis what we are going to study, we have divided that into two buckets: sale and purchase and construction. Sale and purchase and construction. Under sale and purchase, we are going to look at two types: residential and commercial. Okay. And under construction, we are going to look at construction liens. Now, what are construction liens? Let's say I hire a contractor. Okay. Ravneet. Ravneet is a contractor. And I tell Ravneet, I need to construct, or I need to renovate my house, or I need to add an additional floor, or I need to add a ramp, or I need to have a house that is senior friendly. She says, okay, I'm happy to do that for you. She does the construction, but I don't pay her. So how will she ensure that the money that I owe her for her services is secure? She would register a lien. A lien is essentially a charge. I'm going to use something which is technically incorrect, but this will help you understand what I'm trying to say. A lien is similar to a mortgage. What is a mortgage? It is registered against your property, which means you have to ensure that the money that you owe to the financial institution is ultimately paid, right? You've borrowed money from them. Similarly, in case of lien, what happens is that you owe money to a contractor for their services, for construction, right, Iti? I'm supposed to pay Ravneet, right? I'm supposed to pay her $100,000, but I don't pay her. Now, how will she secure her money? What will she do in order to ensure that she gets her money back? Ravneet, what are you going to do?
Put a lien on the construction.
Absolutely. She is going to register a lien against the property. So, when we are going to study the construction aspect of real estate, that is when we are going to dive into construction liens. We are going to talk about the Construction Act. We are going to talk about how liens are registered. What is the time period? I finished construction in January 2026. Can I register a lien in December 2026? Clearly not, because they all have really short limitation period, which means you cannot sit on your claim endlessly. You have a very short window during which you can register a lien. So we're going to talk about those timelines. We're going to talk about what happens if Ravneet, if I return the money to Ravneet. in how do I discharge, or how is the lien discharged? So those are the aspects that we're going to look at. And let me tell you, by the way, construction law is huge in Ontario. So for those of you who are interested in real estate, they can look at closing real estate transaction for the solicitor's perspective, like, solicitor side practice, and then do construction law and combine it with barrister side. It's a very lucrative area. Considering, what are the seasons in Ontario, right? What are the 4 seasons in Ontario? Weather patterns. What are the seasons? You heard the joke? It's winter and then construction. So the only time you don't have construction in Ontario, which is slowly changing now, is winters. So they would say Ontario doesn't have 4 seasons, it has two: winter and construction. So construction, the province is forever under construction. So yeah, for those of you who are interested in exploring the barrister side practice, construction means is huge. Um, then we look at Salem. Yes, Sidra?
Yeah, hi, Hannah. For the construction lien, like you can park it if you are going to refer to this later or during
We
the
have an
session.
entire chapter on construction liens, Sidra.
So should I just park it for then?
Depends on what your question is at the
Like
moment.
the question is when you're trying to register a lien, so will that be in entirety on the property or depending on the value of
It's
the?
always on the entire. So the thing is that depends on what is the value of the money that's owed to you. If it's $100,000, then you will register a lien on the entire property for $100,000.
Okay, and if it's not that huge of an amount,
It doesn't matter.
even then
The
on the entire property.
Of course, I mean, condominiums, your maintenance fee is around $500. And if you've not paid your maintenance fee for about a year, that's $6,000. They will register a lien for $6,000 on your property. So it doesn't really matter what is the value involved. Lien simply means there are unpaid monies.
Okay, got it. Thank you.
So when we talk about sale and purchase, it is here that we further subdivide this into 2 buckets: residential and commercial. Under residential, we will do residential rental, which essentially means what if you want to let out your property on rent? Then we're going to talk about condominiums. We're going to talk about cottage and rural properties. We're going to talk about new homes. And under commercial, we're going to talk about commercial real estate, which is what is it when you buy commercial real estate. This can be purchasing a retail space, purchasing a warehouse, purchasing a manufacturing industrial unit, so on and so forth. And finally, commercial leasing. You want to open a pizza store in a plaza. How do you go about it? So here we would be diving deep into Commercial Tenancies Act, and here we would be diving deep into Residential Tenancies Act. When it comes to condominiums, we would be looking at the Condominium Act. When we would be talking about new homes, we would be looking at the Ontario New Homes Warranties Plan Act. So do you see? Each of these properties are further governed by a statute that is specific to them. So if we were to look at the legal framework, we are going to understand the principles of contract. We are going to understand statute of frauds, because that is mandatory. We are going to then also understand the various statutes depending upon the nature of real estate that I'm purchasing. I am purchasing a second-hand residential real estate. What all am I required to look at? So then, on top of it all, the cherry would be your PR aspects as a lawyer. So we will always, at all times, keep the rules of professional responsibility next to us, and we will also keep the bylaws, because we are not going to understand this from the perspective of a consumer. We are going to understand real estate from the perspective of a service provider. We are going to help our clients close these properties. And therefore, an interplay of the legal landscape coupled with professional responsibility and bylaws constitutes the entire spectrum. And we would be and we touch upon each aspect of it, and then that's how your questions are designed. So you might think it's a real estate question. Turns out it's a bylaw question. Turns out I'm asking you about accounting process. You think it is a professional responsibility question? No. I'm in fact interested in knowing whether you've understood the title clause in in your agreement of purchase and sale. So an interplay of all this is what truly constitutes the real estate portion of your solicitor's exam. All right. Any questions so far? Iti, Ravneet, Karan, Benga, Amanda, Aqua, Irvaneet, Bisoi, Sidra, Delilah. What I love about the fact about Thompson is she always bombards me with hearts. Thank you so much. Rhoda, Sood, Ravinder, Omar, Tirthan, all good. Richa, thank you. Now, let's start looking at the very first topic, which is agreement of purchase and sale. So this is where our journey begins. Before we proceed further, I want you to know that each of these topics has their own visual representation. The visual representation, whether it's in form of a table or it's in form of a chart, some of it is already in your materials. So as we will progress, you will see that we have a table over here. We also have another chart here where we're talking about different types of encumbrances. As we proceed, you would realize that we have various charts that are inside your materials. And in addition to that, we also have charts that are separate, and they would be uploaded in a few days, where you would have something like this, which is a quick reference chart that I have prepared, which will help you revise. These charts are exceedingly useful when you're very close to the exam and you want to quickly revise everything and you go like, oh my God, there is just so much. I don't know if I have the time to touch upon everything right before the exam. So then you will have those charts that allow you to revise quickly. Now, I already explained what are the different stages of a real estate transaction. So broadly, it's agreement of purchase and sale, due diligence, and closing. I also spoke about how contract law is pivotal to real estate. However, there is a legislation that governs real estate transactions in Ontario. This legislation is known as Statute of Frauds. Okay? And in real estate, generally we use standard form of contracts. This standard form of contracts comes from the Ontario Real Estate Association. So for those of you who are not familiar with the concept of standard form contracts, you see, standard form of contracts are those contracts that are pre-written. You don't have to write anything in the contract. So let's say if it has anything to do with your lease agreement or your agreement of purchase and sale, or let's say, if you're looking at a particular appendix, these are pre-printed, pre-prepared contracts. You just fill in the necessary details and you move on. Now, the question that arises is it mandatory for me to stick to ORIA forms? It is advisable to stick to them. Oftentimes, especially builders, they prefer having their own forms, but that's also because they have an entire team of lawyers sitting and preparing these standard form of contracts for them, which are completely one-sided. They barely take into account the interest of the purchaser. However, by and large, and what we are going to study in this, under real estate, is we will be working with Ontario Real Estate Association's form. So we would be looking at the standard form of contracts that are used by Ontario Real Estate Association for each and every transaction. So it's not as if we are going to create our own contract. No, we are going to understand what does clause 8 of a standard form given by ORIA says. ORIA is Ontario Real Estate Association, short form is ORIA. We are going to study what does clause 10 say. We are going to talk about what about clause 15 of ORIA. So we are going to study that particular contract and various clauses that you need to understand. We are not going to sit and write our own contract here. No, that's not our intention. Our intention is very specific to understand the clauses that are given under ORIA's standard form contract, that for this particular topic, the contract is agreement of purchase and sale. Am I making sense here? What is it that we're going to study, Iti? What are we going to study?
We'll talk about the forms in proportion to ORIA, Ontario Real Estate.
Absolutely, absolutely. So we are going to stick to ORIA and we're going to stick to various clauses under ORIA, right? But before we reach there, we will also need to work on some basic concepts. You see, at this point in time, you will feel, oh, our course is moving painfully slow. It's fine because I'd rather spend a lot more time developing your concept instead of rushing through the course. There will be a time when I'll say, okay, today we will take up our course at a lightning pace. And that is because we need to cover swaths and swaths of material. But at this point, we are going to take it painfully slow so that when I use words, when I drop in words like lien or mortgage or encumbrance, you are like, I don't know what it means. So today's class is going to be about working on your basic concepts so that you get familiar with using the same acronyms as I'm using. Essentially, you and I end up talking in the same language. It shouldn't happen when I say whether it's a permitted encumbrance and you were like, but what is a permitted encumbrance? If I use the word VTB, you go like, what is VTB? So we are going to be working on those concepts today. And we did the same in business law. We will do the same in wills and estates. That approach of working on your conceptual clarity, that doesn't change. Now, let's go back. Who is an untitled spouse? What is the position of an untitled spouse in relation to a matrimonial home? Now, let's understand. Let's say I purchase a property in my name because my spouse does not make money. I am the breadwinner, so I get mortgage in my name and I purchase the property in my name. Then who is my spouse in relation to this property? Untitled spouse. My spouse is not on the title of this property. Is the property in my spouse's name Kiranpreet? Is my property in spouse's name Yasmin?
No,
Is my spouse on the title to this property?
no,
So then what is my spouse called?
untitled,
Untitled spouse. Okay. So is the concept of untitled spouse clear to everybody? When my spouse is not on the title to the property, my spouse is an untitled spouse. Now, the next concept is matrimonial home. For those of you who are with me in barristers, you already are aware of the concept of matrimonial home. For those of you who were not with me in barristers, I would take a minute and explain the concept to you. Matrimonial home is the home of marriage, which is where the spouses reside. Now, the question arises, can I have more than one matrimonial homes? Yes, you can. Because there are people who, for 6 months during the summer, live in their cottage, and for 6 months, they live in the city, in Toronto, right? You'd have seen that during the summer, they move to their cottages that are in far-flung areas of Ontario. So for 6 months, they live there, and for 6 months, they live in Toronto because that's where they work, and that's during winter. So, a matrimonial home is a home where the parties reside as a couple. It is a home of marriage. Now, matrimonial home, we dive deep into the concept when we are studying family law under barrister, which is where I talk about how is it split? Can you have more than one homes? What happens if I purchased the matrimonial home before I got married? All those things, they fall under the family law aspect of barrister, which we're not going to study. For the purposes of real estate, we need to know home of marriage is matrimonial home, and the spouse that is not on the title to the matrimonial home is known as an untitled spouse. Am I making myself crystal clear? And the reason you need to know this is because when we start talking about closing the transaction, when we start talking about raising funds for this transaction, at that stage, it is important to identify whether this home is a matrimonial home or not, right? So, if you are someone who wants to purchase a matrimonial home, who wants to purchase a house and then live in that house with their spouse for a prolonged period of time, it automatically becomes a matrimonial home. So, all these aspects become important when we are looking at closing the property, right? Now, what is an easement? Let me explain this to you with the help of an example. Let's say Lorenta owns a property. My house is right next to Lorenta's house, and I can only access the highway if I walk across her backyard or if I drive through her backyard. Her backyard has a small lane, and if I drive through that backyard, I can access the highway. Or if I walk, I can access the highway. What's happening here? What is happening here? Am I not using her property in order to access the highway?
You're trespassing.
No, you have right
Right
to
of easement.
Why?
Very interesting. Very interesting. Yes. If this easement is not registered, I would be trespassing. But when this uh, when this particular ability, or when I have this ability to reach the highway through her property, and if this is registered, it becomes an easement. The word easement simply means right of way. I have the right to use Lorenta's property in order to reach the highway. This is known as easement, right? And so it doesn't really matter whether Lorenta owns the property. Tomorrow she sells it to Fermiza, it's the same. She'll sell it to Fermiza, sells it to Deborah, that's the same. Easement is not owner specific, it is property specific. And it is because of the location of the property. So it doesn't really matter who owns the property. What matters is that it is tied to the property and not tied to the ownership. Am I making sense here? Or did I speak a lot of Greek, Latin, Portuguese, Belgian? Yes, Nivon, what can I do
Yeah,
for you?
what's the difference between servitudes and easement? Like, is it the same concepts or like different?
What?
Servitudes, I have heard.
Okay, I'm going to talk about it. I'll get to that term, but can we focus on easements right now? Slowly. I'll
Right.
get to that term as well. So, when we talk about easements, essentially we are talking about the ability to or because of the location of my property, I am going to use I'm going to use or I need to allow others to use my property so that they can access the road, they can access the highway, they can access a water body, so on and so forth. So it doesn't really matter who is the owner. What matters is the property. And whether or not you have an easement depends upon the location of the property. So tomorrow, let's say Lorenta were to sell that property to Tirthan. Can Tirthan stop me from crossing that property?
No.
You very sure?
Yes.
Are you
If it
very
is
sure?
registered, you cannot be stopped from crossing the property. It won't be termed trespassing. But if it is not registered, then it will be termed as trespassing, just like you've explained.
Okay. So essentially, easement is a specific right that is given to the property owners because they need to be able to cross the other property in order to access. Now, easement also works in very specific ways. Like, for instance, a municipality needs to construct a drain on your property. That's essentially an easement. Telecom companies want to ensure that their wires go under, or go through your backyard. That's easement. Essentially, they are using your property. How do you know? How do you register it? Okay. This is a very good question, Shizom. You figure this out when you're doing your title search. Because if you want to register an easement, it is done in the land titles office. So every time you will undertake um, a title search, it will reveal whether there is any easement or not. So that is known as easement. To answer Nimon's question now, what is difference between easement and servitude? Easement is a specific right that is granted. Servitude is much broader. Easement is essentially a legal term. So, like I said, if you want your municipality to register, or to actually have the drains constructed on your property, or if you want Rogers to ensure that they put their lines from your backyard, all that is very specific. Those are easements. A broader understanding of easements from plain English point of view is servitude. Servitude is very broad. Easement is specific. There's not much difference. The difference is easement is more specific, servitude is broader. That's all. Now, so let's read. Easement is a right that is enjoyed by dominant tenement, which means property receiving the benefit. In this case, my property would receive the benefit over a servient tenement, over Lorenta's property, because she's the one or her property is giving the benefit. For what? For a purpose other than general use and occupation. I cannot occupy her property, but I get to enjoy the benefit by the sheer location of my property. So an easement runs with the land. It binds all the subsequent owners. It doesn't really matter who owns the property. Kiran Preet could own the property. She could sell the property to Delilah. Delilah can sell it to Deborah. Deborah can sell it to Richa. Richa can sell it to Devyani. Devyani can sell it to Oli. Oli can sell it to Fatima. Fatima can sell it to Joan. Joan can sell it to Ramandeep. Ramandeep can sell it to Sidra. It does not matter. Easement will run with it. It binds the property, not the owner. Am I making myself crystal clear here? Okay. All right. So now, from the professional responsibility aspect, it is crucial that when someone comes to you and says, listen, I want to purchase this property, the very first step that you're going to ask for is their identification documents. This is as per bylaw 7.1. Let's fire up bylaw 7.1. LSO's SEO wasn't working. So I'm kind of a little upset with that, but let's see if they fixed it. Okay, is it like it? The SEO was really bad a couple of days ago. In fact, I was talking to LSO and they confirmed it as much that, it's not working in the best manner possible. Where are the bylaws? Bylaw 7.1. Yes. So when you look at bylaw 7.1, everybody, it gives you a list of documents that you need to ask your client if they come to you for a real estate transaction. And this is crucial because of the increasing identity frauds that are taking place in real estate. The number of frauds have skyrocketed. They have exponentially increased. In order to prevent that, or in order to ensure that, in order to curtail that, you have something called identification and verification process. Let me take you to so part 3 of bylaw 7.1 talks about client identification and verification. It tells you when do you need to identify the client, when do you not need to identify the client, because there might be situations when you don't need to identify a client. And those situations are like, your client is TD Bank. Do you really want to sit and do identification process for TD Bank? Your client is a very well-known, you have a repeat client. That client came to you for the sale of their property and then came back to you for a purchase. That means you had already identified, you'd fulfilled the client identification requirements. Your client came to me and I said, you know what? I don't do real estate, but I'm going to do client identification and verification. And then after some time, I refer that client to Sidra. I'll tell Sidra, listen, I'm through with fulfilling client ID requirements. I'm sending the IDs to you. Sidra will not ask the same IDs. So under certain circumstances, or your client is a public body, your client is City of Toronto. Good luck sitting and identifying City of Toronto and taking documents. So in some cases, you will not be fulfilling those client identification verification requirements. But in all the other cases, it is a must requirement. It's not a may requirement. LSO can come after you if you have not fulfilled these requirements. So the question then arises is, what is it that you need to do? You're going to take documents which identifies the client name, client's business address and telephone number. If client is an individual, their home address and home telephone number. If they're an organization other than financial organization or a public body or a reporting issuer, then in that case, organization's incorporation and business identification number. If your client is an individual, then their occupation or occupations. If it is, if your client is an organization, then name, position, and contact number for each individual who will be who will give instructions on behalf of that organization, so on and so forth. So you are going to take these documents that identify these. All right. Now, the question that you need to, or the aspect that you need to be very, very careful about is that you are not going to accept their health card, because Ontario health cards are not a valid form of ID. So you can ask for their PR card, ask for their driver's license, ask for Ontario photo ID, you can ask for their passport, you can ask for their utility bill for a secondary piece of ID, you can ask for their bank statement. Can you ask for their Ontario health card? Iti, what if your client were to give you their Ontario health card as an ID?
No, I won't accept it because it's not a accepted form of ID.
Are you very sure?
Yeah.
Is she right, guys? Is
Yes.
she right?
Yes.
We think so.
You don't think so? It's 100% yes, she's right. She cannot accept Ontario health card, right? So you will ask for 2 pieces of IDs, out of which one needs to be a photo ID, the other one can be a utility bill. It can be a property tax bill. It can be your bank statement. It can be your credit card. All of those are perfectly acceptable. All right. So when a client walks in, what do you first do? Discuss the weather. Tell them how cost of living is going up and how irritated you are with life. And after you've done that, then what do you do?
Client verification.
Client verification. Absolutely. And you're going to take these 2 pieces of IDs. You're going to open a file from practice management perspective. Oh my God, because I've seen 10 on 10 candidates skip practice management completely. Please don't do that. Client walks into your office, you do a conflict check, see if you've represented this client before or not. How is it done is something that I cover in my PR sessions. Finish their conflict check, have a quick conversation with them, evaluate whether they are of a sound mind to give you instructions, take their IDs, open a file in their name, save those IDs, make them sign a client intake, and then start talking about, okay, what is it that you need to do? How can I help you? But these 4 or 5 steps, can I skip them because I'm a little bored with life and I'm like, I'm tired of doing this? Can I skip it? No. All of these steps are must. They're not may. LSO is not giving you the discretion to say, no, it's okay, don't do it. You have to do it. These are must requirements under your PR. So now, when we talk about individuals, you will do a capacity check, which means they have to be above the age of 18. They should not be incapable, which means they have a sound mind and are able to give you instructions, and they are not undischarged bankrupt, which essentially means that if they have been bankrupt at some point, their bankruptcy has been discharged. And we study bankruptcy in great detail in business law. Remember, we had studied bankruptcy. How prepared are you for a bankruptcy quiz right now, guys? Almost all of you attended business law session on bankruptcy. Zia, Ravi, Ravneet, Deborah, Rhoda, Shazom, Nomi, Hazel, Farmiza, Irvaneet. Do I do a quick bankruptcy quiz with you guys? After how many months a person gets automatically discharged if they've never suffered a bankruptcy before?
9 months.
Sidra, not 21 months. Yes, Farmiza, 9 months. Very good. Not 21 months. We need to work on our timeline, Sidra. Yes, thank you, Farmiza. Beautiful. 9 months. So you will check if they have ever been bankrupt. Are they discharged or not? Right? Now, in case of capacity, see, you might have an issue where the individual that you're dealing with is not of a sound mind. They genuinely have capacity issues. In that case, they need to have legal representatives who are in the position to give you instructions. And who are these legal representatives? Estate trustee, power of attorneys, public guardian and trustee. This is Ontario's Office of Public Guardian and Trustee, OCL, or Office of Children's Lawyer. These are the legal representatives, right? In case you have someone who is not of a sound mind or who is not able to give you instructions or who's sheer because they're minors. So, what is the first thing you're going to check? If, let's say, somebody who does not have capacity walks into your office, you will check for legal representative. You're going to check if they have a legal representative or not. And a very crucial aspect of that is you should be able to identify the legal representative, which means if they are an estate trustee, do they have a certificate of appointment of estate trustee? If they are somebody who is your litigation guardian, have they been appointed as your litigation guardian? If they are your if you are someone who's an adult and who's of an unsound mind, you will check for, and if they don't have a litigation guardian, you will check if they are being represented by the Office of Public Guardian and Trustee. If they are a child and they do not have their parents and there is no next of kin, you will check if the Office of the Children's Lawyer represents them or not. So you will check for the valid document that establishes the fact that they are represented by someone who is capable of giving instructions. Now, you might want to ask, do we have such a list? Yes. Do we need to know it for real estate? No. When are we going to discuss this? When we do wills and estates. Because under wills and estates, I talk about power of attorney for property. If you're a child, litigation guardian, like if you're a minor. If you are someone who's an adult who has no other, who does not have a next of kin, Office of Public Guardian and Trustee. If you are a minor, then and let's say your grandparent wants to be the next of kin or wants to be responsible, then we check, do you have a court order that establishes the fact that they are going to be the guardian? So this list that you, so to speak, need, this is covered under wills and estates, and we talk about the process of, let's say, getting guardianship. For now, for the purpose of real estate, if your client walks in and they do not have the ability to give you instructions because they have capacity issues, then you will check what? Whether they have a legal representative who can give instructions on their behalf. Okay? Am I making sense here? Or no? Now, what about a real estate transaction on behalf of a corporation? Now, in this case, when it comes to a corporation, you see, corporation cannot act on its own, right? As someone who's been a corporate lawyer for the better part of her life, I can tell you that when it comes to corporations, you need to the first thing you want to involve is take instructions from multiple people. If there are 5 directors, not all 5 of them can give you instructions. One person has to give you an instruction, maximum 2 people. Now, in this case, you might ask questions like, how will we know whether this person has the ability or has been authorized to give instructions? You're going to check for a very important thing, which is known as articles of incorporation. If the articles categorically identify this person, fantastic. If not, you will ask for a board resolution specifically authorizing this person to represent the corporation or to give instructions on behalf of the corporation. So you are going to first take their IDs and then you're going to ask them, so, Mr. Smith, thank you for sharing your ID. Can you give me a copy of the Articles of Incorporation? And also, if there's any board resolution that specifically authorizes you to give instructions on behalf of the corporation, out comes those documents. You look at them, you check whether they are valid or not. And this is again covered under business law. What kind of resolution are we looking at? Are we looking at an ordinary resolution or a special resolution? In this case, we're essentially just looking at a director's resolution passed by majority of directors. There are 11 directors, 6 directors need to say this person is going to give instructions on behalf of the corporation, and the matter is done. So now you will first ID the person, then you will ID the corporation, and you will check whether this person has the capacity to instruct you on behalf of the corporation. Am I making sense here? Guys? Sometimes I feel, even though I don't know Latin, I feel as if I'm talking in Latin. Because I'm like such delayed reactions. Okay? Now, you need to, like I said, check whether the director in question or officer in question has the authority to enter into this transaction or not. Yes, Deborah, what can I do for you?
I had a question about the director's resolution.
You don't have to get into that. This is something that we discuss in business law. But sure, go ahead. If it is
No,
something
I'm
to
not.
real estate, I can talk about it.
No, I'm not asking for definitions. I didn't hear the last part. Is it a majority of the director's vote?
Yeah,
The
this is
type
usually
of,
in some
okay,
cases it
majority.
is. In some cases, it can be shareholders. In some cases, it can be directors, depending upon the nature of the transaction that the corporation is planning to enter into. If the corporation is essentially into development of real estate, and I'll ask you a question now because you were in my business law class, and they have 80% of their assets as land and they're planning to sell all of their assets, do they need a director's resolution or do they need a shareholder's resolution?
They would need a shareholder's resolution.
You got your
but-
answer. Will
Yeah.
they need a majority? Will they need a special resolution or will they need an ordinary resolution?
They would need a special resolution.
And the reason they would need a special resolution is because they are substantially selling or
Yes.
leasing. They're
Yes.
leasing or selling all or substantially all of their assets.
Mm.
But if it's just a simple it's a simple purchase of a piece of land, which needs to be done during the course of the ordinary business of that corporation, then do you need to go to shareholders for this?
No, not
Then
necessarily.
you got your answer.
Yep. All right. Thank you.
You're very welcome. Now, indoor management rule. I am not going to explain indoor management rule. Plenty of you have been in my business law class. Who is going to take up the baton and explain indoor management rule, guys? Or I'll pick up someone. We studied this extensively in business law. Yes, Sidra?
Yes, when a third person deals with a corporation and has reasons to believe that the person they are in contact with has authority to decide or act on behalf of the corporation, then you are saved by the Indo management rule. So basically, you do not have to verify whether that person is under authority. You are saved. It is used as a defense that it was done in good faith, and you thought that they are abiding by the articles and bylaws of the corporation, and they are under authority to give advice on behalf.
Of the corporation.
Yes,
Okay.
on behalf of the corporation.
All right. I need 2 more candidates to explain this to me, please. Because I'm not going to discuss this. We discussed this so much in business law. Do I pick up or are you volunteering? Okay. Ravi, indoor management rule.
Whenever you meet any representative of any business organization, you are under belief with a good faith that that person has the authority on behalf of business organization to deal with, and just in case the matter goes to the litigation, you have got a defense that yes, he was representative of the business organization and I dealt with it.
Correct. Farmiza, indoor management rule.
Indoor management rule is something where but other parties can assume that the corporation is valid. There is no need to record the documents to see whether the corporation exists or not. So they can
Not
assume
exist, whether they have the ability to deal with.
whether they deal with that. Yeah.
Rhoda, indoor management rule.
Hi, can you hear me?
Yes.
Yeah, it's a protection for outsiders that are dealing with corporation in good faith, so it allows them to assume that the internal company procedures have been followed.
Correct. Zia, indoor management rule. Zia?
When you're meeting with the third party, so it's all about the corporation representative, like you believe so that he is he's already his name is already incorporated into the articles to take any kind of decisions for the company.
Not indicated in the
For the
articles. They have the
corporation.
ability to take decisions on behalf of the company or deal in the
Yeah.
manner that they are dealing with outsiders, and that they have the authority to deal with such with they have the authority to act on behalf of the corporation. This is essentially a rule of defense.
Yeah.
Superb. I am very happy. You guys have been revising business law. I like. You are preparing for your test on April 26th. Although I'm not sure, should I go easy on you or not? And given that I will not go easy on you, so study harder. Because, yeah, so I'm actually looking forward to your test on April 26th. You guys are studying. I like. Okay, so we will read indoor management rule from here. The indoor management rule holds that the third parties that deal with the corporation are entitled to rely on the assumption that the corporation has adhered to its own rules, that you don't have to go and check whether this person has the authority or not, or whether this person is acting according to the internal procedures of this corporation or not. At common law, a person dealing with a corporation, assuming that he or she is acting in good faith and without knowledge of any irregularity, need not inquire about the formality of the internal proceedings of the corporation, but is entitled to assume that there has been compliance with articles and with the bylaws. Now, what is the rule of sale and purchase when we talk about a partnership firm? Again, we had discussed this. Section 6 of the Partnerships Act says business law.
Just representation agent for other partners.
Correct. They have the ability to bind the other partners for an act that is done in the ordinary course of business. Remember that? Remember that speeding ticket example that we had done? If you're doing something in the ordinary course of business, what do? You bind the partnership. That's what it means. So if it is about purchasing property for a partnership concern, you know that the partner will be able to bind the other partners as well. Correct? Section 6, Partnership Act. We remember that, don't we? Yeah. Excellent. Can I ask another question for business law? I am a partner of the firm. I will claim CCA on my, I will deduct capital cost allowance separately from my income. True, false?
Sorry, you got cut out in between. If you could just please repeat the question.
I am a partner in a partnership concern, and I should be allowed to claim capital cost allowance separately on my assets because I have a share in the assets of the partnership as well.
No.
False. Absolutely right. Yes, you're right. CCA, capital cost allowance, is claimed at
Partnership.
partnership level. Can I exit just one asset of the partnership?
No.
No.
Thank you very much. I'm so glad you guys are studying. All right. Now, so when we talk about sale of real estate in case of partnership, one partner can execute a binding agreement, and because they have an agency relationship, they can bind the other partners as well. Now, when we talk about power of attorney, because we're looking at real estate transaction just right now, the ability to enter into real estate transaction. So we did for individuals, we did for corporations, we did for partnerships. Now, what about entering into a real estate transaction because you have been instituted as the attorney? In this case, you're going to check few things. Number one, you're going to check whether power of attorney is even valid or not. Second, you're going to check for the signatures of the grantor and the witnesses. You would check with the compliance with the Substitute Decisions Act 1992. You don't have to worry about what this statute is. I'm going to take this up when I do wills and estates. You will check the capability of the grantor at the time that they gave this power of attorney. Like you will check, like I said, the validity. It cannot be expired. It has to be good and relevant as of date. You are going to check for specific for an event that triggers its use. Now, although I'm entering into the realm of wills and estates, let me just quickly explain. Let's say I have a power of attorney for personal property, and I have given that power of attorney to personal property to my sister. Now, in that power of attorney, I have categorically stated that if I am undergoing a terminal illness, then my sister will be able to sell one of my properties and use that money towards my treatment. Okay? Now, my sister comes to Joan and says, Joan, I want to sell this property. Joan says, sure. Are you the owner? No, I'm not the owner of this property. Okay. Then you are selling this property as, well, I am the power of attorney holder, or I was instituted as an attorney for property by my sister. Okay. Can I see the attorney? Power of attorney? Sure. Well, Joan will ask, listen, it says you can only sell this property if your sister has a terminal illness. Is that the case? Yes, Joan, she is not well. I need to sell this property. so that I can use the funds for her treatment. Sure. So that means now the event is triggered. And this trigger was given in the power of attorney itself. Do you see what I'm trying to say? The power of attorney, which allows my sister to sell the property, categorically states that it will start breathing. The power of attorney will start breathing because it has not been brought to life technically. The power of attorney will start breathing when the event will get triggered. Did the event get triggered? Sure. I'm suffering from a terminal illness. My sister needs to sell the house in order to ensure that she can pay for my treatment. So now has the event been triggered? Yes, no. So she will be able to sell the house. So Joan will see, okay, the power of attorney is valid, signed at the time Hina gave this property, gave this power of attorney or instituted her sister as the power of attorney. She was, she was capable and she had the ability to give this property or to give this, to make her sister the attorney. And now this power of attorney contains a trigger event that has happened. So that means that now this property can be validly sold and there is no fraud that's happening here. All right, am I making sense? So when somebody walks into your office and says, I need to sell this property, well, and I am doing this because I have a power of attorney, those are the things you want to be looking for. You want to check the signatures, you want to check compliance with Substitute Decisions Act, you want to check the capability of the grantor, you want to check the validity of power of attorney, you want to check for specific event that triggers its use, you want to check if it has any other conditions, you also want to check if the power of attorney has been revoked or terminated, or if the grantor is alive. So these are the factors, these are the rules for verifying power of attorney. I'm going to ask you a trick question. Why is this question important? Why do you want to check whether the grantor is alive or not? Come on. I would be very, very happy if somebody could answer this question.
Just in case the grantor is no more, then the power of attorney is no more valid. It's valid just during his lifetime, his or her lifetime.
To avoid fraud.
No, what Ravi said was absolutely right, because once the person is dead, you want to look for their will and see how that property needs to go. Why will you be looking at power of attorney there? That's why you want to see whether the grantor is alive or not. Correct? Thank you, Ravi. That was absolutely right. You want to check it because, well, if the person is no more, then the property will go as per the will. What is power of attorney? What will the power of attorney do in this case? Because the power of attorney dies with the grantor. In case of an untitled spouse, now I spoke about the situation where there is an untitled spouse, right? Now, in case of a matrimonial home, like I said, matrimonial home is it's a different beast altogether when it comes to real estate. And the reason I'm saying this is because even though the spouse is not on title, you cannot sell the matrimonial home without their consent. You cannot get a mortgage without their consent. So in case it is a matrimonial home and you want to sell the matrimonial home, well, your spouse is not on the title. Then what is it that you're going to do? Then in that case, you will get a power of attorney from the untitled spouse. The power of attorney has to explicitly authorize the titled spouse to go ahead and sell the property. The registration of deeds on the basis of power of attorney, also you need consent of the untitled spouse. It's just not possible. Am I making sense here? Now, I'm going to discuss a piece of legislation with you, which is Prohibition on Purchase of Real Estate Property, Residential Real Estate by Non-Canadians Act 2023. The first thing that I want to say, and I have been saying this since last year when the extension came in, that it came in January 2023. And initially, when it came, it was only supposed to be for 2 years. But last year, in the year 2025, it was extended by another 2 years. So now, effective 2021, Jan 1st, 2021, up until Jan 1st, 2027. Initially, when it came, it was for 2 years. Now it's for 4 years. So it's up from 4 years from 2023, which means now it is till 1st January 2027. But what is till 1st January 2027? You see, because of the housing crisis and the increase of property prices, the Canadian government had come up with a legislation that specifically prohibited non-Canadians from purchasing residential real estate. All right. Now, what this essentially means is that they would not be able to invest in a condo or purchase a detached home or purchase a semi-detached or a townhouse. They wouldn't be able to do it, right? And that was to ensure that it improves the affordability in Canada when it comes to housing, and that people should not hoard property. And also it wanted to ease out rentals because they had become terribly expensive. So in order to control the property market and in order to prevent it from spiraling further, they came up with this legislation. This legislation said that effective Jan 1st, 2023, if you are a non-Canadian, which means you're neither a Canadian citizen, and you're not a permanent resident, and you are someone who is not an Indian registered under the Indian Act, you are prohibited from purchasing residential real estate. And that ban essentially, initially was for 2 years. It was supposed to expire on 1st of January 2025. I think it was last year, or I think in December 2024, when it was extended by another 2 years, which means now you cannot, if you're not a Canadian, you cannot purchase residential real estate up until January 1st, 2027. Am I making sense here? The question that was then asked by multiple candidates is, Hannah, can they invest in commercial real estate? Answer is yes. They can continue to invest in commercial real estate. They cannot invest in residential real estate. Now, another question that was asked was, what happens if they entered into an agreement of purchase and sale, let's say on 25th December 2022? Well, they would still be able to consummate that transaction. They would still be able to close that transaction, because if your agreement of purchase and sale has been entered into prior to January 1st, 2023, you will be allowed to close your transaction. Am I making sense here? So you will check if including refugees as an exception. I need to check about refugees. I cannot say for refugees. I haven't read the legislation in that
the
detail.
material.
It's in the materials? Okay. All right. Then it includes refugees as well. So, no, the restriction does not. If you're a registered Indian under the Indian Act, that means you're essentially in Canada. So, in that case, now you can purchase. If you are a refugee, as Omar says, you can still purchase the property. Now, in that situation, if you I don't know, I just lost my chain of thought. I was talking about agreement of purchase and sale being entered into prior to 1st January 2023. You would be able to complete your purchase. And let's say if about commercial real estate, you can continue to invest in that. And the ban initially was for two years. Now it has been extended to 4. Yes, a very important aspect of this was there were certain exceptions, right? When we talk about who is a non-Canadian, they said an individual who is neither a Canadian resident, no, a Canadian citizen, nor a person registered under the Indian Act, nor a person permanent resident. Yes, this is what I wanted to talk about. A corporation that is incorporated otherwise than under the laws of Canada or the province. What does this mean? Now, let's say you are a corporation, but your corporation is such that you have been incorporated, or your corporation is based out of the Middle East. Can your corporation purchase residential real estate? No, you cannot, under no circumstances. If a corporation is incorporated under the laws of Canada or province whose shares are not listed on a Canadian stock exchange, designated Canadian stock exchange, for which a designation under this is Income Tax Act. Now, what does it mean essentially is that let's say you are you have a corporation, and that corporation is incorporated in Canada, right? And the shares are not listed on any Canadian stock exchange. But the people who control this corporation are outside Canada. And you go like, what does this mean? I would actually take you to Ontario Business Corporations Act. Remember, in Ontario Business Corporations Act, we study that there are no residency requirements for the directors. Correct? That means you can be incorporated under the statutory regime and yet not be residents of Canada. So that means you can be a corporation that is incorporated in Canada, but the people who are controlling this corporation are neither permanent residents and they're not in control of this corporation. Can this corporation invest in residential real estate?
No.
No. You're absolutely right. So, in law, we have a principle, things that you cannot do directly, you can also not do indirectly. So it cannot happen that, oh, let me incorporate something, and then the people who are controlling this corporation, the shareholders and the directors, they're not from Canada. And now this corporation wants to purchase land, residential real estate, sorry. They still won't be able to do it. Right? So it is very clear about what you can and cannot do. And let me tell you, if you bypass this, there is a heavy penalty, very heavy fines and penalties, almost up to $10,000. So it's not as if you will find out ways and means to bypass this. The legislation is watertight. So when it comes to residential real estate, if you are not a Canadian resident, if you're not a Canadian, if you're not an Indian registered under the Indian Act, or if you're not a refugee, as Omar says, but I will go back and check once again. If you're not one of these, you cannot purchase land. Also, if you are a corporation that is incorporated in Canada, but not controlled by one of those 4, you can still not purchase real estate. Right? Initially, this ban was for 2 years. Now you cannot do it for, I think, till 1st of January 2027. However, if you had entered into, let's say, an APS for a condominium on 31st October 2022, the condominium is still under construction. Can you then close that transaction? Yes, because your APS predated 1st of January 2023. Okay? And this does not include commercial real estate. I was actually I was asked to do an opinion, and I'm not really going to get into the findings, but it was very interesting. Let's say you have invested in a warehouse, right? And now you can invest in a warehouse. After some time, you decide, and you're not a Canadian, so this ban is not applicable. This ban is applicable to you from the perspective of residential real estate, but not commercial real estate. And let's say you want to convert that warehouse into a condominium, because what ends up happening is that you also have residential conversions, which means the property initially began as a commercial real estate but is now moving to residential real estate. How does this ban impact? It was an interesting opinion that I had to do. And we had to look at plenty of aspects. It was an interesting opinion. Now, what is a title direction? Directing title simply means, and it simply means how are you going to take on the property. Now, for instance, my full name is not Henamal. I am Henamal Vaidya. So all my documents identify me as Henamal Vaidya, but you all don't know. But can I take the property in the name of Henamal? No, because I don't have any ID or any other proof that says that's my name. My name is really long, and therefore all my identification documents have my complete name. Now, in that situation, I will give, and let's say I'm purchasing Iti's property. Iti would be like, yeah, I know her. Her name is Henamal. No, I will actually have to give a title direction categorically stating first name, last name. This is how I'm going to take the title to the property. What is this? This is title direction. I am giving the direction to Iti's solicitor, telling them exactly how I want the property to be. If, let's say, I'm purchasing this property with my sister, then do I want to take it on as a joint tenant, or am I going to take it on as a tenant in common, or is it going to be tenancy in common? That means, how will the property be assumed when it comes to the title to the property? Name, in terms of the number of parties who are purchasing this property, how are they purchasing this property? Joint tenants and tenants in common, right? Are they taking on this property as two partners, or are they taking on this property as two co-owners? Because remember, we had done this in business law. Partnership is a different structure from co-ownership. What was the defining feature? Partnership being different from co-ownership?
In co-ownership, you own the property together, but you're not running a business. As in a partnership, two or more people run the business together.
Absolutely, but there is a very specific distinction that I'm searching for.
You do not own the property in a partnership.
No. There's a very specific distinction. You're right. Guys, what is the difference between owning a property as partners and owning a property as co-owners? Yes, Tirthan, you can claim capital cost allowance individually if you are co-owners. But if it is a partnership, the property belongs to the partnership and you cannot claim CCA individually. Thank you so much, Tirthan. Beautiful. So you need to categorically indicate how are you going to take title to this property. So directing title is the simplest and the most common way to ensure that the third party becomes the registered owner of the property on closing. A purchaser will execute the direction on or before closing and present it to vendor's solicitor. The conveyance is then drafted in the name of the transferee, and therefore this is very, very important how you take on the property. I've had issues where People have all sorts of name, and there is a very important cultural aspect to be understood over here. So when it comes to names and whatever, you have to be very, very clear about what you're doing. Now, can somebody tell me the difference between joint tenants and tenancy in common? Again, not something I'm going to talk about. We have discussed it so much, so many, 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 many times. Are you volunteering or do I pick up? I don't mind. Yes,
Joint
Keitana. Yeah.
tenancies come with the survivorship, right of survivorship, and tenancy is common is divided between like fraction of shares between the parties.
Beautiful. Absolutely right. When it comes to joint tenancy, it basically means that if something were to happen to one of the owners, the property automatically passes to the surviving tenant, right? So let's say if if I own this place with my sister in joint tenancy and something were to happen to me, the property automatically goes in the name or is, now stands in the name of my sister because she's the surviving tenant, right? If this were a joint tenancy, in that case, my share of the property will go to my estate. It will not pass on to my sister. It will go to my estate, and then how it passes on further will be determined by my will. It will not get automatically transferred to my sister because she is the surviving tenant. Am I making sense here?
I have a question.
Sure.
In joint tenancy, you said that since your sister is a surviving tenant, the property passes on to her. And if you could just tell me the second part, I'm just getting slightly confused.
In second part, it goes to my estate. It goes to my, so you know the concept of estate, right? It goes
Yeah.
to my estate, and then what will happen to the property will be determined by my will. I can
And
simply say that
what's that part called? The second part called?
joint tenancy in common.
Got it. Okay, thank you.
So there are two parts to it. Joint tenancy, tenancy in common. Joint tenancy means it automatically passes on to my sister, and that's because she's the surviving tenant. In tenancy in common, it goes to my estate, and then what happens to the property will be determined and will be in accordance with my will. In my will, I can still leave it to my sister. That's fine. But then you'll have to undergo the entire process of probate. You'll actually have to get a certificate of certificate of appointment of estate trustee with a will. There will be an estate trustee. Estate trustee will read out the will. In the will, I have left it to my sister, which is fine. But then you have to have a proper process that would be followed, right? Once again, we cover this in wills and estates. So I'll just quickly read out. Joint tenants, when purchasers choose to own property as joint tenants, each owner has an invisible interest in the land, and each owner has what is known as the right of survivorship. The right of survivorship means that on death of one of the owners, the ownership of the property automatically transfers to the surviving owner. This means that if two individuals own a property as joint tenants, just give me a minute, guys. So, sorry, guys. I was talking about my sister. She appeared. I needed something warm to drink. So in this case, the right of survivorship means that on the death of one of the owners, the ownership of the property automatically transfers to the surviving owners. This means that if two individuals own a property as joint tenants and one of them dies, the surviving owner becomes the sole owner of the property, right? In case of tenancy in common, when the property is owned as tenancy in common, the owners have a divided percentage interest in the ownership of the property. Except, however, there is no right of survivorship. So in case if there are two owners, they own the property in equal 50% shares, and one of the owner dies, the deceased owner's 50% share passes on to their estate and does not automatically transfer to the surviving owner. Therefore, the deceased owner's share will be dealt with as a part of the administration of their estate. Does this make sense to you, Ithi, now? Everybody, is this clear? Any questions?
Sorry, hello. Did I say percentage? Is that not like a percentage when it has
Yeah.
regards to
Yeah,
tenancy?
it is. Yeah, it can be a percentage. You can do it a 50-50, you can do it a 70-30. Depends
Okay.
on what is the percentage of property that you wish to own. 1 second. There's somebody by 512718. Can you please tell me? Now, let's go back. So it doesn't really matter. You can have like a 50-50 split, Shazom. You can have a 70-30 split. It just your agreement needs to be drafted accordingly. That's all.
Oh.
All right. Now, how does one deal with the issues of tenancy in common? Through a co-ownership agreement. Remember, we were just discussing, you're essentially co-owners. So you will have to have a co-ownership agreement. Now, your PR aspect comes in. Co-owners should have a separate legal representation. And you need to search the title of the property before ideally, you should be able to do it before your client enters into agreement of purchase and sale, but usually that's not how it happens. Lawyers are only involved once the APS has been signed, but at that stage they say APS has been signed, but it's not firm yet. And it becomes firm only after certain conditions have been waived in the agreement of purchase and sale. It also becomes firm when you want to do especially in case of a condominium, you want to do a quick check with, go over the condominium's bylaws. You want to go through the constating documents of the condominium. Then in that case, you can say it has become firm. So most of the times the APS has already been entered into and it is subject to certain conditions. Sometimes it's a financing condition. Sometimes it is, I need an inspection condition. So there can be plenty of conditions. Ideally, this should be the case, but it doesn't really happen that way. Co-owners will have separate legal representation. Why do they need to have separate legal representation, guys? Which aspect of PR is important here? Absolutely.
Confidentiality.
Conflict, not
Conflict of interest.
Conflict of interest. Right? And is there a way to bypass this?
No.
Waiver.
I'm searching for a better answer. What kind of retainer will allow you to take them? Absolutely. Joint retainer. Section 3.4-5 of the Rules of Professional Conduct. Now, question. I have been named as an estate trustee in a will. Can I execute a registrable transfer to the title? No. Just because I have been identified as an estate trustee in the will, I cannot go automatically and sell the property. I will have to be appointed as an estate trustee through a certificate of appointment of estate trustee, and this is done under Rules 74 and 75 of the Rules of Civil Procedure, and they are all set to change in Ontario. I don't know the situation with other provinces, but rules of civil procedure are undergoing a major overhaul. Like we are getting a different rule set altogether. How will this look like after that? Well, for those of you who are interested in civil litigation, you should read the rules, the report by the rules of Why is it going to change? Well, because the rules are dated. They haven't been changed since 1985, and it's high time they do change. The rules of civil procedure first came, I think, in 1908 and then in 1913, and they underwent a major overhaul either in 1954 or 1965. Don't quote me on the year. And then in 1985. So now they constituted a committee on the review committee on civil procedure rules, and they've come up with a report last year or earlier this year. It was either in late December 2025 or Jan 2026. And yeah, we are going to see a massive overhaul. Like, they are doing away with discovery process. They are going to do away with the action and application proceedings. Now you'll just have different tracks of litigation. So for those of you who are interested in civil litigation, keep an eye. Plenty of free CPDs being given, and you can read that report. It's an interesting report. And let's see how that impacts access to justice and other aspects. But yes, they are going to undergo a change. So currently, these are, when I'm talking about as of today, estate trustee via appointment of estate trustee under Rules 74 and 75 of the Rules of Civil Procedure, that governs your entire estate litigation. So you will check whether a valid certificate of appointment of estate trustee with a will has been given by the court. And if it has been given by the court in accordance with the rules of civil procedure, superb. Now you can execute a transfer. But just because you have been identified in the will, that is not enough for you. Let's say I have been identified. That's not enough for me to go ahead and sell the property of the estate. No, 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 no. I need this document. Does this make sense? So, what happens is that when you're doing a real estate transaction in Ontario, you basically do it over a software that's known as TerraView. And I'm going to talk about TerraView in our future sessions. Now, when you're closing a transaction or while you're, completing the transaction, you identify the law statements that are applicable to that transaction. So for those of you who are not familiar with law statement, let me just say this. Law statements are statements of fact that basically they identify the nature of the property. Like, for instance, there is a law statement which says this is a matrimonial home. There will be a law statement which says this home is being sold by trustee in insolvency or licensed insolvency trustee. There will be a law statement which says that this is being sold by this property is subject to estate sale. There might be a law statement which says this property is being sold pursuant to expropriation under Expropriation Act. So these are statements that are given on TerraView, right? These are statements of fact. So you click on the relevant statement to identify the nature of the property that is being sold. This property is being sold pursuant to an estate sale. Fantastic. You will click on it. And from the practice management perspective, you will just say, give me a copy of this certificate of estate trustee with a will, and I will keep it in my records. Because these facts have to be backed by evidence. And this evidence has to be a part of your file that you maintain for the client. Now, if I say this property is being sold under the Expropriation Act, or this property is being expropriated by the municipality, well, I will have a look at the expropriation agreement and put it on my file. So selecting these law statements is very, very important because that tells you in which capacity the transaction is being, is taking place. And we're going to talk more about the law statements as we proceed. We're going to talk about your professional responsibility aspect, etc., etc. But for now, is it clear why you need to have a certificate of estate trustee with a will? And you cannot just go ahead and sell the property because, well, I've been named as the estate trustee in the will. Is it clear? It is necessary to take that document, identify who is selling it, and keep a copy of that document for your records as a backup evidence. Am I making sense here? Any questions, anybody? Fatima, Yasmin, Loretta, Inyola, Delilah, Sidra, Ilona, Lorenta, Ivranit, Deborah, Rhoda, Shazom, Tom, V, Tirthan, Emmanuel, Fatima, Devyani, Manjeet, Amanda, Benga, Maria, Nivon. Yes, Deborah, what can I do for you?
Just a quick one. The certificate of appointment is for an estate trustee, right?
It is the correct terminology is certificate of appointment of estate trustee.
Okay.
With a will, without a will. We'll discuss that in wills and estates. But yes.
Okay. Thank you.
Oh, you liking this, Yasmin? I'm so glad. She's saying thank you for this wonderful lesson. Thank you so much. I'm glad you're liking it. You guys genuinely enjoy law. By now, I would have slept. My God. So boring. Not interesting at all. Can a seller be a non-registered owner of the property? Yes. If the sale is being done by the sheriff, or if it is a power of sale, or it is done by trustee in bankruptcy, you're not the registered owner of the property, but you're still selling the property. Are you not? I just told you, you're not. Are you the owner of the property if you're selling it pursuant to a bankruptcy? No, you're not. Sheriff is doing it, or licensed insolvency trustee is doing it. You're not allowed to dabble in the property, unless, of course, you're Donald Trump, to whom the laws of lowly mortals like us does not apply. If that's not the case, for normal people, you won't touch your property if you have been declared bankrupt or undergoing bankruptcy. Yes, an agent can sell too. So yeah. The only exception, like I said, are the Trumps. They can do anything. Now, how is the sale of matrimonial home different from other real estate? I think I said this earlier as well, that when it comes to matrimonial home, it doesn't really matter who is on the title. If the titled spouse attempts to sell the property without the permission of the non-titled spouse, the purchaser may end up obtaining a title which is subject to spouse's legal interest. And you don't want this for your client. And therefore, it is imperative that when you do your title searches, and then you ask requisitions, you categorically state or ask if it is a matrimonial home or not. And you cannot afford to lie on that. So you cannot say, oh, I will say it is not a matrimonial home, but in reality, it is a matrimonial home. It is considered fraud, and there are definite legal ramifications that you might not be able to deal with. And then there'll be damages. So, yes, Shazom?
Yes, Hannah. So, thank you. What you're saying is that matrimonial homes are being registered.
Yeah, what about it?
No, like because of what you're saying now, like if you want to sell a matrimonial home, so it must you must include the non-title owner to it. So what I'm saying is that do you have to register it? Like if, for instance, I bought a home now and it happens to be a matrimonial home, so I have to register it for the prospective buyer to know that it is actually a matrimonial home or not.
You don't have to register, you will have to declare it,
Oh,
whether it's a
declaration.
matrimonial home or not, yeah.
So I declare it to who? To which authority?
Oh gosh. There's no authority. You would let the buyer know, their solicitors know, in the agreement of purchase and sale, it will be identified as a matrimonial home.
Okay.
You don't have to identify, there's no authority that you're identifying it to. You are, and you will write this, even you will click on the law statement as well, whether it is a matrimonial home or not.
Okay, I get
The
it.
time of closing. Yeah.
All right, thank you.
Why is it not letting me? Yeah. So, since similarly, the non-titled spouse will be required to consent any mortgage transaction. Likewise, if the consent is not obtained, the lender's security will be subject to non-titled spouse's interest. Now, you see, when you purchase a property, the description of the property needs to be bang on. It needs to be accurate. So, what is the most accurate way of describing a property? You will attach the latest survey. So in case of large lots, the Ontario Land Surveyor will measure the dimensions of the parcel while preparing the survey. Now let's look at understanding agreement of purchase and sale. You see, whatever we are discussing, I told you I already have a quick reference chart. So this is to let you know exactly what all you need to look at. Or let's say if you don't have the time in the exam to go over those pages, a chart like this will help you clearly identify where you need to search for the answer, right? So issues regarding buyers. So when it comes to title directions, you need to let them, just because I am agreeing to buy does not mean only my name would be there on the title. A written title direction needs to be given. When you're talking about multiple buyers, then it needs to be categorically stated. How are you going to take the title to the property? When it comes to agreement of purchase and sale, what are the issues that are unique to the seller? So this kind of chart will help you prepare, or will help you, it becomes your cheat sheet in the exam, because at the end of the day, you do not want to be stuck with pages and pages of notes and you don't have any ready reckoner to go to. Yes, Sidra?
Hannah, will this chart be provided or we rely on the recordings?
No, this chart would be uploaded.
Okay, thank you.
Yeah. Now let's look at understanding the agreement of purchase and sale. When we look at, do you have any other questions, Sidra? Okay. Yes, Deborah?
Just in addition to what Sidra said, will we be able to print it? Will
No.
we have access?
No.
So we copy it out.
Okay.
Yeah. Okay.
None of the materials can be printed. They cannot be downloaded. And that's true for every material, Deborah. You need the materials. You write them down from the computer, open them up, fire a laptop, write whatever you need. Draw whichever chart you want on your materials. None of these materials are allowed to be printed or downloaded. Okay? It's as simple. There is a reason I don't sell these materials. And also, I constantly work on them. I constantly update them, and new materials are posted. You guys don't even realize, because it's pretty much the same. I've changed a word or I've changed a year. I've updated them. So, no, these materials are always a work in progress. We are constantly working on them. So, when we talk about agreement of purchase and sale, there are certain clauses that we need to understand. The first is known as the title clause. The title clause governs the quality of title that you're going to get, right? The quality of title the vendor is required to bestow upon the purchaser. So, in this case, the kind of title you want for your client is clear, good, marketable, free from any encumbrance except permitted encumbrances and restrictive covenants. So I need my title to be squeaky clean. It should be good, it should be clear, it should be marketable, it should be free from any kind of encumbrance except permitted encumbrance and restrictive covenants. And if my title search reveals that I am not getting this kind of title, then please do not be trigger happy and say, terminate the agreement. No, that's when you're going to wear your negotiator's hat and get the best possible price for your client. You will seek a price abatement. This needs to be the first recourse. You please do not go to straight away terminate the agreement. No, you're a lawyer. You have to think like a lawyer. Negotiating is something that we do for a living. So you will seek a price abatement. That will be your first recourse. You can ask for damages, extend closing, but then in this case, it requires the consent of both the parties. You cannot unilaterally extend the closing date. And then you terminate the agreement. You will, if you're given 4 options in the exam, and if you click on termination of agreement and then you ask me, why did I not pass? Well, that's because you did not follow the simple ladder approach. Termination comes right at the end. It's not the wrong answer. It's just that it's not the first answer. It's not the first thing you're going to resort to. Okay? Now, clause 13 talks about the inspection clause. What is inspection clause? Inspection clause simply says that I am going to purchase this property subject to inspection. And what does this mean? It means the property will be inspected by a licensed inspector who would look at the property from both within and without. So they would do a quick check on the roof. They will check if there's any leakage. They're going to check if there's any issues with, let's say, the windows. They're going to check if there's any leakage. They're going to check if, the wiring is done properly. They are going to inspect the property from the perspective of habitability. The property needs to be habitable, right? If, let's say, you start living in the property and the basement starts to leak, or the roof starts to leak, or there's an issue with the foundation, or if there are cracks in the wall, or if you realize that, okay, there is a leakage of air and heat, well, that means the inspection was not done properly. So when you sign an agreement of purchase and sale, you plug in a condition which says this will become firm only after the inspection has been fully done to the satisfaction. And if you're like smart, so for your clients, you will end up negotiating this phrase saying that to the satisfaction of the buyer, which means that if I'm not happy with the inspection report, even if the inspection report says everything is hunky-dory, I can go ahead and close the property. I can still say no because the inspection is nice, but I still don't feel confident enough because I still think it's an old house. I still think I'm not sure whether wiring is updated or not. There's nothing wrong with the wiring, but you're still using copper wiring. I'm not happy with that. So then those are the little things that you end up negotiating for your client. Otherwise, a simple inspector's report will tell you whether the property is habitable or not, whether it's safe to live in or not. And if that's the case, that clause is removed from the agreement of purchase and sale, and you can go ahead and call it a firm APS, right? So typically it takes about a couple of days to get the inspection results and things like that. So a home inspection is a clause. It is a provision in the APS that states that the sale of property is contingent on the results of home inspection. Sellers are under no obligation to disclose patent defects, Patent defects are those defects that are visible to the naked eye. I can see the defect, right? So that's a patent defect. A latent defect. Yes, Iti, you have a question?
You said are visible to the what?
Naked eye, naked eye. As you can
Naked eye.
see it.
Okay.
Like if you see that there are cracks in the wall, then the seller is not supposed to tell you that there are cracks in the wall. You can see it, right? Anything that is visible to the naked eye, that's patent, apparent, right? The other kind of defect is a latent defect. A latent defect is a hidden defect, which means that seller themselves are not aware of it and they're not under any obligation to disclose. Like, for instance, there's a problem with the foundation of the house. The seller will not know. So if they don't know and the inspection cannot possibly reveal it, then that's a latent defect. So both latent defects and patent defects, the sellers are not required to disclose. Patent because it's visible to the naked eye, and there's a concept of buyer beware, which is caveat emptor. You should have been able to see it. And latent defect because the seller themselves are not aware of it. So latent and patent, you don't need to reveal. But let's say if you're aware of a latent defect and you did not disclose, now there is a problem, right? So, because that means that you knew about it and you did not disclose it. So then in that case, I can sue the seller, right? So therefore, it is important that to understand what will your inspection report truly reveal. Okay. However, sellers are under an obligation to latent defects that they have the potential to render the property unfit for habitation or adversely impact the cost of the property. In the event the seller does not disclose the latent physical defect, if they're aware of it, then it may constitute fraud. Okay. I also want to do some practice questions. Can we progress to practice questions, please? Because there is no class without a practice question. Also, you know the drill in practice questions. Do I read the practice questions or do you read them?
You read it.
I never read practice questions.
I saw one of your recordings in which you were reading, so
One of them,
okay.
way off.
Okay.
June 2026, it's a policy. I don't read it because you know what ends up happening? My lecture ends up becoming a monologue and you will sleep.
Okay.
So if there are different voices, it does not become a monologue and you stay awake through the session if you're listening to the recording. So do I pick up candidates or are you volunteering?
I can read one.
Sidra can read one. Iti, you're definitely reading one. Ravneet, you are reading one. Ravi, you are reading one.
Sure.
Who else? Rhoda, you're reading one. So practice questions. Here is your first practice question, Sidra. Come on.
XYZ Corporation is interested in purchasing a commercial property in downtown Toronto. The company's board of directors meet and discuss the potential purchase, but no formal resolution is passed authorizing the transaction. The CEO of XYZ Corporation, John Doe, signs the agreement of purchase and sale on behalf of the corporation. The APS includes the full legal name of the corporation, XYZ Corporation, but the names and offices of the signing officers are not listed. The seller, ABC Real Estate Limited, is aware of XYZ Corporation's CEO signing the APS and proceeds with the sale. ABC Real Estate Limited does not inquire whether the CEO had proper authorization to sign on behalf of XYZ Corporation. As the transaction moves forward, the buyer's solicitor, Sarah, is tasked with reviewing the agreement. Upon reviewing the documents, Sarah realizes that the CEO of XYZ Corporation may not have had the proper authorization from the board of directors to sign the APS. She begins to wonder about the legal implications of the incomplete authorization. Which of the following is most likely true regarding the validity of the agreement of purchase and sale between XYZ Corporation and ABC Real Estate Limited? A. The APS is invalid because the CEO of XYZ Corporation did not obtain the proper authorization from the board of directors. B. The APS is likely valid due to the Indo management rule, which protects third parties from incomplete authorization as long as they are unaware of any internal issues within the XYZ Corporation. C. The APS is invalid because the names and offices of the signing officers were not included in the contract. D. The APS is valid only if the board of directors of XYZ Corporation passes a resolution authorizing the purchase of the property. For me, the answer is B.
Okay. Rhoda is saying B, Samarin is saying B, Deborah is saying B, Sidra said B. Okay, yes. B is the answer. Given that indoor management rule protects the parties from any incomplete authorization, etc. Iti, you go
Okay,
next.
sorry, Hina, 1 second. We have Indo management rule. Okay, for example, we don't have B as an option. Is C?
But why would B not be an option? B
No,
is the
like
only correct option.
that's correct. I agree. But if the APS is invalid, can it be invalidated because the names and offices of signing officers were not included?
My question is, if it is a corporation, then why do we have indoor management rule?
Okay, we can proceed without those details also.
Yes. No. You are supposed to have those details from the lawyer's perspective. You are not going to go ahead and complete a transaction without it. But the question is, does that render APS valid? Let's say if you are representing the buyer, right? And you go like, now if you're representing the buyer, seller's due diligence is not on you. Are you going to sit and do seller's due diligence, Sidra?
No.
You are going to rely on what they are saying.
Okay.
This is upon this seller's solicitor to sit and do the due diligence on their behalf.
Correct.
Iti, yes.
James and Anna are a married couple and they jointly own a matrimonial home in Ontario. Anna, due to health reasons, has granted her brother Michael a power of attorney to act on her behalf in relation to the sale of the home. Michael presents a power of attorney to the buyer's lawyer to complete the sale transaction. The power of attorney document is provided to the buyer's lawyer, but upon review, the lawyer notices that the power of attorney does not explicitly authorize Michael to provide the consent of Anna as an untitled spouse to the sale of the matrimonial home as required under Section 21(1)(a) of the Family Law Act. Given this concern, the buyer's lawyer begins to assess whether the power of attorney is valid for this specific transaction. If the buyer's lawyer determines that the power of attorney does not explicitly authorize Michael to consent to the sale of the matrimonial home, what action should be taken to remedy this issue? A. The buyer's lawyer should proceed with the transaction as the POA is otherwise valid. B. The buyer's lawyer should request that Michael obtain a new power of attorney that explicitly grants authority to consent to the sale of matrimonial home under Section 21(1)(a) of the Family Law Act. C. The buyer's lawyer should advise the seller to obtain a court order to proceed with the sale without the necessary authorization in the power of attorney. D. The buyer's lawyer should have Michael sign an affidavit confirming that he has authority to provide consent to, can you just go down a bit? Sorry.
No, that's fine.
Confirming that he has the authority to proceed for the consent of the sale of the matrimonial home.
Yes, the answers that are being given in chat box are correct.
Yeah.
The buyer's lawyer should request that Michael obtain a new POA, right? Rhoda, your turn, please.
Okay.
Rhoda?
Yeah. Michael is selling his home in Ontario to Sarah. The property is listed for sale, and Michael has provided the standard agreement of purchase and sale, which includes an inspection clause, paragraph 13, stating that the buyer will have the opportunity to conduct an inspection of the property before completing the purchase. During a routine inspection, Sarah's inspector notices some visible cracks in the foundation and a high radon reading in the basement, which Sarah later learns is well above the recommended safe levels. Sarah is concerned but proceeds with the purchase after negotiating a minor price reduction. After the sale is completed, Sarah discovers that the foundation is severely compromised and the radon levels are dangerously high. She later finds out that Michael, the seller, was aware of both the foundation and the high radon levels, but did not disclose these issues prior to the sale. Michael argues that he did not need to disclose these issues because the agreement made it clear that the buyer was responsible for inspecting the property. Sarah is now considering legal action against Michael, claiming that the failure to disclose the defects constituted fraud. Based on the principle of caveat emptor and the inspection clause of the agreement, which of the following is the most likely outcome regarding Michael's duty to disclose the defects in the property? A. Michael is not required to disclose any defects because of the caveat emptor principle, and the inspection clause in the APS made clear that Sarah was responsible for inspecting the property. B. Michael is required to disclose the foundation and radon defects because these defects render the property unfit for habitation or would be so costly to repair that they significantly reduce the property value. C. Michael is only required to disclose the foundation defect, but he is not required to disclose the radon issue as radon is invisible, undetectable defect. Or D. Michael is only required to disclose defects that affect the property's markability, not defects that affect its safety or habitability. Yeah. Answer is B for me.
You're absolutely right. B is the right answer. Let me see. Have we done vendor take back mortgage? We've not done these questions. Okay, I think we've only the other question. We have not covered the portions for others questions. I'm going to end the session here. I'm going to meet our regular candidates on Tuesday at 7:30. We will continue with our discussion. Please watch the first recording from November 2025 session and the second recording from November 2025 session so that you're able to cover what I intend to cover in the next session on Tuesday, right? And I will see you at 7:30 on Tuesday, 7:30 Eastern Time. I hope you guys enjoyed the session, you liked the session, and yeah, and if you want to enroll, please speak to Amar. Most of you are already our candidates, but in the event you're like, some of you, I know a couple of you are not our regular candidates. If you wish to enroll, please speak with Amar and enroll before Tuesday. Take care and have a lovely Sunday. I hope
Thank
it's
you.
sunny wherever you are, because in Ontario, the place where I live, the weather is throwing a tantrum.
Thank you.
Take care and have a great day. Bye-bye.
I know.
Yes, Paulia?
Before you hang up, can I just ask you a question?
What?
You can come off recording. I just want to ask you a question before you go.